Hey class, welcome to week 10. Today we are going to begin our discussion of judicial review, which we're going to wrap up next week in part 2. So we have been talking about ways that we, the public, hold agencies accountable. We do that through public access, through financial liability for harm caused, as well as through judicial review. And so today we're going to take a look at judicial review, why and how courts can review the acts of agency officials and the executive and legislative branches in general. The concept of judicial review as we know it today was set out by Alexander Hamilton in Federalist Paper number 78 and was cemented in American jurisprudence by the Supreme Court in Marbury v. Madison, which we will cover shortly. So thanks to Hamilton, if you sue the government for infringing on your rights, the courts are able to hear your claim because of the doctrine of judicial review. The doctrine also allows courts to overturn executive and legislative branch acts and even compel another branch to act as required by law. So judicial review, it sets forth the authority of a court to hear a case. It is rooted in the concept of separation of powers and checks and balances because it allows the judicial branch to review acts of the other two branches. So where does the authority for judicial review come from? The Constitution does extend judicial power to various types of cases, such as those that arise under federal law, but it doesn't make any comment as to whether a court can strike down a law or a regulation or some other form of legislative or executive action. Congress does provide for judicial review in statutes. So if there is statutory authority for it, that's where the courts get the authority. But the real power behind judicial review comes from the U.S. Supreme Court. So given that agencies present a separation of powers problem, judicial review is really at the heart of administrative law. It operates as a check on agency authority and on agency discretion because it's a method of questioning whether the government actually has the authority to take a certain action. So courts can scrutinize an agency's statutory authority to regulate, that sandbox in which the agency can play, as well as official agency decisions and other agency actions. Courts can also review the adequacy and fairness of agency procedures to ensure due process and equal protection. So intertwined with the concept of judicial review is the concept of jurisdiction, and that also relates to a court's authority to hear a case. There are several different types of jurisdiction. We are going to take a look at the Supreme Court's jurisdiction first, and then later we're going to examine the concept of jurisdiction itself in more detail. So first, let's take a look at how the doctrine of judicial review took hold in the United States. And it was the Supreme Court that officially recognized this doctrine in Marbury v. Madison, which we will discuss momentarily. As an aside, the U.S. Supreme Court, it's a beautiful building. It is well worth seeing if you happen to be in D.C. It is not on the National Mall, so you got to go a little bit out of your way to get to it, but I definitely recommend it. If the court is in session, you can sit and listen to oral arguments. You got to get there really early if you want to stay for the whole argument, particularly if it's like a hot button issue. But if you just want to hear a few minutes of the proceedings, you can join a small group that rotates through the gallery so that you can see the Supreme Court in action. So there are currently, or there should be, 9 justices on the Supreme Court. This number is not set by the Constitution. The Constitution is silent about how many justices should sit on the court. Now, the Constitution does mention the office of the Chief Justice, but it mentions it as part of the impeachment process where the Chief Justice presides over the Senate trial. The number of Supreme Court justices has changed quite a bit, particularly throughout the first 100 years of American history. We have had as few as 5 justices, we have had as many as 10. So the Judiciary Act of 1789, Congress originally set the number of Supreme Court justices at 6. Then in 1801, another act of Congress reduced it to 5. By the beginning of the Civil War, we had 9 justices, but that was for practical reasons, not political reasons, because at the time, Supreme Court justices actually had to travel to hear cases. They would travel the circuit along with circuit court judges. So westward expansion before the Civil War created this need for additional justices to cover more geographical territory. Under President Lincoln, we had 10 justices, and that was political. It was to ensure pro-union decisions. Congress then cut that number to 7 to deny President Andrew Johnson the ability to fill a seat. Unfortunately for Congress, at that point, the Supreme Court ruled that paper money was unconstitutional. That would have wreaked havoc across the country. So in 1869, Congress added 2 more justices so that President Ulysses S. Grant could appoint the justices who would reverse that paper money decision. So, number of justices changes, but we've stuck with 9 for a while now. Like all members of the federal judiciary, Supreme Court justices are appointed by the President and confirmed by the Senate. As with most courts, the majority of personnel at the Supreme Court are kind of behind the scenes. So the Supreme Court's got about 450 support staff. That includes 4 law clerks per justice. It also has its own police force called the Supreme Court of the United States Police. That police force protects the Supreme Court building itself, as well as justices, employees, guests, and visitors. Cases before the Supreme Court are tried en banc. That means that all 9 justices hear the case together as a group. So if you argue a case in front of the Supreme Court, you're going to do so in front of all 9 justices, and any of them can question you. Each case heard by the court then results in an opinion. We hope for a majority opinion, but sometimes it is a plurality opinion. So a majority opinion is any opinion where at least 5 justices agree on the outcome, as well as the analysis and reasoning that led to that outcome. A plurality opinion is one in which no single opinion received the support of the majority in both outcome and rationale, but the plurality opinion, the one that's being published as the court's decision, received more support than any other version. A lot of times, a plurality opinion is actually a situation where the majority of justices agree on the outcome of the case, but they differ in the analysis of the law that leads up to that outcome. Then there are dissenting opinions, justices who disagree with the majority or the plurality. They can write their own dissenting opinion. That does not have any impact on the outcome of the case, but dissents can be very important for future cases. So the Supreme Court's geographic jurisdiction, it covers the entire U.S. and its possessions. So cases that originate in Puerto Rico or Guam can make their way to the U.S. Supreme Court, same as cases that originate in Colorado or Florida. The Constitution is the source of the Supreme Court's jurisdiction, and the Constitution gives the court both original jurisdiction and appellate jurisdiction. And what this means is that sometimes the court hears cases that are filed directly with it, and it acts as the trial court. And then other times, more frequently, the court hears cases that were filed initially in a lower court, and they got appealed up to the Supreme Court. The Supreme Court's original jurisdiction, the ability to act as a trial court, that is very limited. It's really for cases between the states. So, Colorado sues Maryland. That can be filed directly with the Supreme Court. It is also for cases that affect ambassadors and diplomats. For all other cases, the Supreme Court has appellate jurisdiction. So the actual trial takes place in a lower court, usually a district court, gets appealed to a court of appeals, and then gets further appealed to the Supreme Court. So the U.S. Supreme Court hears appeals from all of the U.S. courts of appeals. If some type of federal question is involved, such as the constitutionality of state action, the Supreme Court, the U.S. Supreme Court, will also hear appeals from the highest court in each state. So if you have argued something up to the Colorado Supreme Court, let's say, and there's a constitutional question in there, you can then jump from the Colorado Supreme Court to the U.S. Supreme Court. But now keep in mind, the U.S. Supreme Court, it does not have to hear cases on appeal. Its appellate jurisdiction is within its full control, and the court declines to hear the vast majority of appeals. The one time where the Supreme Court will almost certainly hear an appeal is when there is a circuit split. When one federal court of appeals has ruled one way and another has ruled another way, that creates an inconsistent application of the law, and so the Supreme Court then steps in to settle the issue. So why do we have judicial review at all? Well, we have it because of a Supreme Court case in 1803 called Marbury v. Madison. So this picture here is an inscription that's on the wall of the Supreme Court building, and it says, it is emphatically the province and duty of the judicial department to say what the law is. So this concept of judicial review had been around since the early 1600s, and at that time, English courts decided that they could nullify acts of parliament, and those are statutes the same as laws passed by Congress. The concept of judicial review was lost in England later in the 1600s, but by that time it had taken root in the American colonies, and it survived on this side of the Atlantic. And the concept of judicial review was very widely discussed in a very positive light at the Constitutional Convention. It's also discussed in the Federalist Papers. There's a lot of back and forth about the need for judicial review. So Marbury v. Madison was a really fascinating case at the time. All of the people involved were very well known. Like if this were happening today, Bravo would have a reality show about it. Because it was really, people were riveted by this case. So the key players, we've got John Adams. He was at the time the president of the U.S. He was a member of the Federalist Party. At the time, we had the two-party system was the Federalists and then the Democratic Republicans. So at the time of Marbury v. Madison, Adams had been voted out. So he was a lame duck president. William Marbury, also a Federalist, was one of Adams' last-minute judicial appointees. Then we've got John Marshall, newly appointed as the Chief Justice of the Supreme Court. He is the first Chief Justice who really made an impact. So when you think about the history of the U.S. Supreme Court, it actually really starts with him. But in addition to being the new Chief Justice, John Marshall was also the acting Secretary of State for John Adams. Then we had the incoming president, Thomas Jefferson. TJ was a Democratic Republican. Now, you may be aware that Jefferson and Adams engaged in a lifelong debate, sometimes an intense rivalry. They actually died on the same day, which was the 50th anniversary of the signing of the Declaration of Independence. And they wrote to each other constantly. But at the time of Marbury v. Madison, they were not on the best of terms. They had had a falling out. Federalists and the Democratic Republicans basically disagreed with each other about everything, which is not terribly different than what we have today. And finally, there's Jefferson's Secretary of State, James Madison. Okay, so what happened? John Adams, who is a Federalist, lost his re-election to Thomas Jefferson, who is Democratic Republican. And at the same time, the Federalist-controlled Congress lost as well. So the incoming Congress was going to be controlled by the Democratic Republicans. So the Federalists were very unhappy with this situation, but they still had power during this lame duck session. And during that session, the Federalists passed the Judiciary Act of 1801. That modified an earlier Judiciary Act in a number of ways, including adding more federal judges and federal justices of the peace. So at the last minute, Adams appointed, and the Federalist-controlled Senate confirmed 16 Federalist circuit court judges and another 42 justices of the peace. And these were called the Midnight Judges because they were appointed literally almost at midnight, right before the clock struck 12 and control of Congress was transferred from Federalists to the Democratic Republicans. So William Marbury was appointed as a Justice of the Peace in D.C. But in order for his appointment to take effect, the papers had to be delivered by the Secretary of State. So at the time, that was John Marshall, who had also just been appointed as Chief Justice of the Supreme Court. Adams had signed the appointment letter for Marbury, but Marshall hadn't been able to deliver it. He just ran out of time. And he assumed that the incoming Secretary of State, James Madison, would go ahead and deliver the appointments because they had technically been properly submitted and approved and were technically legally valid. So we've got an appointment that Marshall hasn't delivered to Marbury, but he thinks Madison's going to deliver it. Instead, Jefferson takes office and tells Madison not to deliver the appointment. So Marbury never gets his Justice of the Peace job. And he goes ahead and sues in the Supreme Court. And he says that this new Judiciary Act actually gives the Supreme Court some original jurisdiction, and he can go and file directly with the Supreme Court. So Marshall says, okay, yes, Marbury has the right to the appointment, but the Judiciary Act of 1801 actually conflicts with the Constitution. And the Supreme Court doesn't have the power to tell the Secretary of State what to do in this case. So the end result was that Marbury got screwed out of his job, but the Supreme Court got the final say over all laws passed by Congress. The Supreme Court in Marbury v. Madison established that it's got the power to interpret the Constitution and statutes and really hold Congress and the executive branch accountable. So the questions from Marbury v. Madison, it said, the first question is, does Article 3 of the Constitution, which sets up the judiciary branch, create a floor for original jurisdiction, or does it create an exhaustive list of original jurisdiction that Congress can't modify? So in other words, can Congress add to the types of cases that can be filed directly with the Supreme Court? And the court said no. Congress cannot change the Supreme Court's original jurisdiction because it is set forth in the Constitution. The Constitution has the final word on it. And Marbury v. Madison, the opinion, also basically said, look, if there's a conflict between Congress and the Constitution's going to win. The Constitution trumps laws that are passed by Congress. And more importantly, for judicial history, Marbury v. Madison says that it's the Supreme Court that gets to decide the conflicts between Congress and the Constitution. So Marbury never got his job, but the Supreme Court got the power to act as this major check on the power of Congress. So while we can thank the U.S. Constitution and Chief Justice Marshall for the doctrine of judicial review as we know it today, like I said earlier, Congress can also provide for judicial review via statute. If Congress sets out a process for judicial review in a statute, so it's providing for statutory review, then courts have to strictly adhere to that statutory process. So the statute sets forth the only way to get into court and have the court review that law, unless there is a constitutional issue involved. If there's a constitutional question or a federal question, federal law, then the courts can usually adjudicate it regardless of what Congress says in the statute. That said, Congress can limit the ability of courts to review statutes. It usually does this via a time limit called a statute of limitations. So you may have to file suit within, say, 60 or 90 days from the date that you knew or should have known that you had a cause of action to get into court. If you miss that filing deadline, the window of jurisdiction closes and the court can't hear the case. Congress can also limit judicial review based on the location of a suit. So for example, if you want to sue the IRS, you have to do so in Washington, D.C. or in a specialized tax court. Congress can also place some limits on the manner in which you can raise your suit. For instance, you might not be able to file suit in court until you go through a disputes process within the agency that you want to sue. We call this exhausting the administrative remedies, and we'll talk about it more next week. Congress is not supposed to be able to limit judicial review of federal questions, so these are issues that relate to the Constitution or other federal laws. This does not mean that Congress does not try, it's just not usually successful in its efforts. So what happens if the statute itself does not provide for a specific type of judicial review, and there's no constitutional issue raised? Well, then the courts have to turn to common law doctrines as their source of authority. So the common law provides a substantial amount of authority for the judicial branch to review the acts of the other two branches. Common law is judge-made law. It's been handed down since colonial times or even pre-colonial times. As we just saw in the US, justices as well as judges basically decided that they had the authority to engage in judicial review, and it became part of the common law. While the concept of judicial review as we know it today is a decidedly American invention, the common law itself actually dates all the way back to the reign of William the Conqueror. So after the Norman invasion of England in 1066, William the Conqueror combined Saxon, Danish, and Norwegian legal precedents and made them common to the whole Kingdom of England. So that's why we call it the common law, and that's also why many of our common law doctrines sound like they come from ye old days. So one of those doctrines is certiorari, or cert. This is the process to seek judicial review of a decision by a lower court or a government agency. In the US, we see this doctrine most frequently at the Supreme Court. The party that files an appeal to the Supreme Court is hoping that the court will issue a writ of certiorari. That calls the case up to the Supreme Court. And a writ, that's just an old-fashioned term for the issuance of official paperwork. If the Supreme Court doesn't want to take the case, then it usually issues a simple statement that just reads, cert denied. So it's not going to call the case up in front of it. Another common law doctrine is an injunction. That's a court order that either that commands you to do or not do certain actions. So for instance, if your neighbor keeps parking her car on your lawn, you can go to court and get an injunction to make her stop, intruding on your private property. Habeas corpus, that is another writ. It literally means show me the body. And it is the method by which a court orders a government official to bring a detained person physically in front of the court. That's what the court's saying, show me the body, bring the person here. And that allows the court to determine whether the government has the authority to continue detaining that person. In today's legal system, we see this most frequently with prison inmates who believe that they have been unlawfully imprisoned. But like all of these common law writs, habeas corpus is a civil proceeding, not a criminal one. So we see it mostly in the criminal side of things, but it itself is not a criminal doctrine, nor is it a criminal proceeding. The final common law doctrine we'll cover is mandamus, also a writ. A higher court will issue a writ of mandamus to a lower court or to a government official, and the writ requires the court, the lower court, or the government official to properly fulfill its official duties or correct an abuse of discretion. So now that we know the authority for judicial review, let's talk a little bit about jurisdiction. Jurisdiction is based on the characteristics of an individual case, so primarily the subject matter, the parties, and the geographical location where the acts or omissions took place. So you look to whether a court is going to hear a criminal case, a civil case, or some type of specialized case like bankruptcy. You look to the parties. Are the parties persons, actual people plus corporations, and are they located in the same state or are they in different states? Is the U.S. government a party, either as a whole or through an agency or through a specific official? Same for the states. Is the state government a party? All of that matters in determining which court has the authority to hear the case. To think about it in sort of a simpler fashion, let's say you get into a car accident in downtown Denver, and you live in Boulder, and the other driver lives in Colorado Springs. Well, you probably want the case tried in Denver because that's where the events took place, that's where the witnesses were, that's where the police who came out and wrote up the report about the accident are located. So because everything took place in Denver, you would want a court in Denver to hear that case. Now, we have been talking about hierarchical jurisdiction, where cases start at the lower courts and they appeal their way up to the higher courts. At the same time, policy issues, they start at the top and flow down. So at the federal level, the U.S. Supreme Court sets policy via its decisions, and all of the federal circuit and district courts must follow that policy. Horizontal jurisdiction, on the other hand, is determined by the case type. A court can split its jurisdiction into categories, and it does that often to help manage caseloads within the court system. So for instance, civil courts and criminal courts, they're the same level of court, they're trial courts, but they hear different types of cases. There can be additional subdivisions. So a civil trial court might be separated into courts that handle all civil cases under a certain amount, like $10,000 or less. That would be a small claims court. They might be, family law, divorce cases, juvenile court. So you can split up jurisdiction horizontally. Same on the criminal side. Criminal trial courts are usually split between misdemeanors and felonies, and they also include specialized courts like drug courts or traffic courts. So a reason for horizontal jurisdiction is that it allows judges to become experts in a specialized field of law, and then it also helps the court balance its workload. Now, federal courts can only hear cases that the federal law puts within their jurisdiction. All the other cases in the U.S. are heard in state courts and sometimes in tribal courts. So there are a couple different types of federal jurisdiction. First, we have federal question jurisdiction. That gives federal courts the authority to hear any case that requires a review, analysis, or application of the U.S. Constitution, federal laws and regulations, and international treaties. Second is federal party jurisdiction. If the feds are a party to the case, you sue them, what have you, then the federal courts have the authority to hear the case. So you can't drag the federal government into a state court. Third is diversity jurisdiction, also known as diversity of citizenship cases. These are civil cases that are worth more than $75,000, where the parties are citizens of different states, or where one party is a citizen of a different country. And we've got diversity jurisdiction because the framers wanted the federal courts to have jurisdiction in cases where citizens of two different states are involved, because the framers didn't want to risk a situation where a state court is biased in favor of its own citizen. So for instance, if a Maryland resident gets injured at a ski resort in Colorado and sues the ski resort in Maryland, it's possible that the Maryland state courts would be biased in favor of their Maryland resident. So instead, the ski resort in Colorado could move into federal court. Jurisdiction also has geographical limits, which we call venue. Venue is strictly geographical. It's all about the location of the parties or the events that are involved in the case. Parties can waive issues of venue. So as a Colorado resident, you can consent to be sued in Maryland, but the parties cannot waive jurisdiction. If a Maryland court does not have jurisdiction, that Maryland court cannot take the case, even if you are willing to travel to Maryland. Defendants often ask for a change of venue if they believe that local prejudices are going to make it impossible for them to receive a fair trial. Requests for change of venue are rarely granted. Most of the time we see them in high-profile cases where the judge thinks, yeah, the local community, which is providing the jury pool, is so prejudiced against the defendant that the defendant's not going to receive a fair trial. We saw this back in the 1990s with the O.J. Simpson murder case that had a change of venue. In 2012, the Aurora movie theater mass shooting case that also had a change of venue. And right now, the defense attorney for one of the former officers charged in the murder of George Floyd recently filed for a change of venue, arguing that his client can't get a fair trial in the Minneapolis area. As I mentioned earlier, Congress can impose restrictions on federal court jurisdiction. It often does so in the form of these statutes of limitation. Those cut off a court's authority to hear the case once a certain amount of time has elapsed. And that's just to be fair to all of the parties. If you're going to get into court, you want to do so as quickly as possible while the events are fresh in everyone's memory. Congress can also define the jurisdiction of lower federal courts in a way that eliminates their ability to hear certain cases. So for example, there was a 1996 immigration law that stripped federal courts of jurisdiction to review certain immigration decisions. There are statutes that limit the number of habeas corpus petitions that prisoners can file, so that effectively curtails judicial review. But Congress's limitations on judicial review, they've got to comply with the Due Process Clause. If Congress is going to limit review, it has to provide some type of constitutionally appropriate process, or the plaintiff has to have a reasonable chance of somehow getting into the court system. Congress is not supposed to limit judicial review of constitutional questions. The Supreme Court has strongly implied that it would not accept such a limit. But Congress can limit review in cases that don't involve constitutional issues, or it can preclude review entirely so that you can't get to court. Congress can preclude review by showing clear and convincing evidence in the language of the statute. So, for example, and we've got this on the screen, when Congress passed the Smallpox Emergency Personnel Protection Act, it very clearly said that no court could have subject matter jurisdiction to review any action by the Secretary of Health and Human Services and or his or her designees. So if the Secretary makes a call to protect government personnel from smallpox and you disagree with the action taken, that's too bad, because Congress has provided clear and convincing evidence that it does not want you to be able to challenge the Secretary's actions. And in this type of case, there's a good reason to preclude review. It's not like Congress just decided willy-nilly that Americans can't challenge Health and Human Services. Instead, because it was a matter of public health and safety, Congress determined that it was best for agencies to be able to take action to contain smallpox outbreaks without worrying about being sued. Now, there are plenty of times when Congress tries to strip a court of jurisdiction on social issues, and that almost always fails. So, for instance, there was a bill in 2005 that would have prohibited the U.S. Supreme Court from hearing cases that involved a government official's acknowledgement of the Christian God as the supreme source of U.S. law. That type of acknowledgement would clearly violate the First Amendment, which protects religion from government and protects government from religion and applies to non-believers as well as believers of all religions. Same type of thing has happened with Public Prayer Protection Act, other types of laws that claim to safeguard religious liberties but really favor a certain type of Christianity. And often these bills don't ever get through a House of Congress because Congress knows that the statute's going to be struck down. That was the case with several bills that would have prevented the federal courts from reviewing official public prayers, displays of the Ten Commandments, or other limits on First Amendment privileges. And no matter what Congress would like to think, federal courts can hear these cases that involve religious liberties or other civil rights, as well as these general attempts by public officials to impose their religious views on everyone else. So now that we have talked about the basics of jurisdiction and judicial review, let's just talk briefly about standing and ripeness. So in order to get into court, you have to have standing and your case needs to be ripe. So these are two sides of the same coin. Standing is the question, do you have the right to be heard in court? Ripeness is the question, does the court have a right to hear your case? So your case has to be ripe enough. The defendant has to have gone so far in his or her detrimental behavior that a court can now step in and hear the case. And we are going to talk more about ripeness next week. For now, we're going to focus on standing. Standing is the requirement that the plaintiff, be it an individual, a group of individuals, an organization, or even a unit of government, it's the requirement that the plaintiff have a personal interest in an actual case or controversy. Basically, the plaintiff has to have something to lose. It's got to have some type of skin in the game. And that is because the Constitution, in Article 3, Section 2, limits our federal courts to cases or controversies. That requires an actual dispute, not a theoretical or future dispute. The only exception to the need to have an active case or controversy is that there are some statutes that grant automatic standing where you don't have to be personally affected by the case. Statutes impact standing, and standing impacts judicial review. If a statute is silent, then common law principles of standing apply. If a statute expressly limits review, the statute applies. And if a statute expressly provides for review in excess of common law's principles, then the statute applies. And our notion of standing has evolved. So traditionally, the plaintiff had to prove that the defendant violated the plaintiff's legally protected interest or right. On its own, the fact that the plaintiff suffered a financial or a physical injury, that was not enough to establish standing under the traditional test. So that meant that the courts had to address the merits of the case, kind of dig into the meat of the case, in order to determine if the plaintiff had standing. That meant that a court might litigate the whole case only to find out that the plaintiff did not have standing, had no right to be heard in court, and so everybody just wasted their time and money. The traditional test of standing, it worked well enough back in the day when the United States was rural and agrarian, but it's just not workable in an industrialized, modern society. So the growth of government, society, and the increased number of cases in front of courts require that the court system adapt a more flexible approach to the concept of standing. So now we've got the modern test. It has 3 prongs. That's injury, causation, and redressability. The injury prong requires that a plaintiff's injury must be an actual injury. So typically it's an economic injury where the plaintiff has lost money, or a personal injury where the plaintiff is physically or emotionally injured. The causation prong requires that the defendant is the one who caused the plaintiff's injury. In administrative law, that typically means that the plaintiff had to be injured by agency action. So whatever the agency did, issuing a regulation, inspecting the plaintiff's business premises, must have somehow injured the plaintiff. And then finally, the injury has to be redressable. That means that if a court finds in favor of the plaintiff, the court has an ability to fix the plaintiff's injury. When it's an economic injury, that's pretty easy. If the plaintiff lost $500,000 because of an incorrect agency action, then the agency pays the plaintiff $500,000 and we're done. For other than economic injuries, it can be more challenging to determine how to appropriately compensate the plaintiff for his or her loss. Non-economic injuries come up a lot in things like environmental class action suits. These are times when groups like the Sierra Club sue the government because at least one of their members has suffered some type of non-financial harm, such as the loss of public lands. So this happened in Colorado when the Roan Plateau was open for drilling and fracking. Colorado citizens who had enjoyed hiking and snowshoeing and camping on the Roan Plateau sued, alleging that they would be injured by the loss of their ability to enjoy the natural beauty of Colorado. So these environmental law cases, they provide standing to people who want to protect the environment as long as those people can show some harm to their own interests. Scenic Hudson Preservation Conference, that was kind of hailed as the birth of environmental law as a separate branch of law in the US, but it's important because of the way that it deals with standing. So this was a 17-year-long dispute. It started back in 1963 when Consolidated Edison basically announced that it was going to build a big power plant on Storm King Mountain. They were also going to buy up 300 acres of an adjoining forest. And in response to the proposal, citizens formed the Scenic Hudson Preservation Conference. They wanted to oppose the project. And for the first time, the Supreme Court held that aesthetic harm suffices as a type of injury in fact to establish standing. So in this case, the Storm King project that Con Edison was going to do, it was going to be located in an area of unique beauty as well as major historical significance. It's, these gorges of the Hudson River, they're actually some of the most beautiful river scenery in the world. And so the court's decision to grant standing to the Scenic Hudson Preservation Conference that established an important legal precedent for similar groups to be able to take legal action to protect the public interest in the environment. Lujan versus Defenders of Wildlife in 1992, that was the next big case about standing to sue in environmental cases. So in this case, Fish and Wildlife Service had issued a regulation stating that the Endangered Species Act applied to agency actions in foreign nations. This got a lot of pushback because the U.S. funds a lot of projects abroad that would probably be hindered by regulations and laws if they were happening here in the U.S. So Fish and Wildlife changed its position and said, no, 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 the Endangered Species Act only applies within the United States. So a group of environmentalists challenged Fish and Wildlife because they believed that, it was right the first time. The Endangered Species Act should apply anywhere in the world if it's the U.S. government taking action that might harm an endangered species. What the Defenders of Wildlife said is that right then and there, during the trial, none of their members were viewing those endangered species, but sometime in the future they might want to see an animal that no longer exists because the U.S. government destroyed its habitat. And the Supreme Court said that a future injury is too much conjecture. There needs to be some type of present injury and present controversy. And in the Lujan case, the court noted that it would have found standing if even a single member of that group, the Defenders of Wildlife, had booked an airline ticket to go and take a look at an endangered species. As long as a single person in that membership organization suffered an injury, the court would have found standing and would have heard the merits of the case. In a different case, but also involving Fish and Wildlife Service, Bennett v. Speer, the court held that plaintiffs did have standing because they were suffering a present injury. In that case, Fish and Wildlife had issued an opinion. It wound up harming the plaintiff's economic interests in lake waters. The court held that that harm was indeed traceable to Fish and Wildlife Service and would be redressable, or that is resolved, by a favorable judicial ruling. They could basically make Fish and Wildlife Service retract the opinion that was causing economic harm. So there are some additional specific applications of the standing doctrine that apply in administrative law. I mean, they apply everywhere, but they come up in administrative law because we're focusing on federal agencies. And remember, that standing doctrine is you have to be injured, the defendant had to cause your injury, and the court has to be able to address your injury. So some of these other doctrines would be standing for American citizens and taxpayers, standing in whistleblower cases, environmental cases like we just saw, and cases involving business competitors and consumers. So for quite a while, Americans would use their status as an American citizen to sue the feds over laws that they didn't like. And that created a lot of work for the courts. And eventually they decided that just being an American citizen in and of itself does not create any right to challenge federal expenditures. If you don't like how the government is spending money, you're not alone. About half of us don't like what the government's doing at any given time. So that is not enough to get you into court. You need some type of added injury. Similarly, the fact that we pay taxes does not give us a right to challenge government spending in general. However, as taxpayers, we do have standing when the government's expenditure violates the First Amendment's Establishment Clause. So if the government gave a whole bunch of money to the Mormon Church to set up, a church in DC, we would be able to challenge that as taxpayers because that violates the First Amendment Establishment Clause. There is a separate type of citizen standing, and that's authorized by statute. And that category includes whistleblower cases, which we also call qui tam cases. And in those cases, a private citizen brings suit on behalf of the federal government, not against the government. The government can intervene and take over the case. If they decline to do so, then the private citizen, who is known as a qui tam relator, in case that ever comes up on Jeopardy and you want to impress people, that private citizen can prosecute on behalf of the government. And the qui tam relator is awarded anywhere from 15 to 30% of recovered damages. So for instance, a couple years back, Duke University settled a massive qui tam case It agreed to pay the feds $112 million for submitting falsified grant proposals. And in that case, the whistleblower got around $33 million. Speaking of money, competitors, they are not always an obvious interested party, but competitors can have sufficient interest to have standing. So where an agency action is going to affect an entire industry, then there are usually numerous competitors with standing. Be careful that you do not confuse membership organizations with competitors. Membership organizations usually don't compete with anybody. They're not engaged in a for-profit business. It is possible that members of the membership organization would meet the definition of a competitor, but that does not make the membership organization itself a competitor. But if you think back to, the GM versus FERC case that we've looked at a couple of times, that's an area where GM got standing because it was a competitor. Consumers also can have standing, particularly in class action suits. So in those cases, like if a regulated party doesn't challenge agency action, it's possible that individual consumers would be unprotected. And so as not to deprive consumers of due process, the courts have held that consumers can have standing based on things like pricing or reduction in the quality of a product. The most familiar form of this type of standing are class action suits that seek to stop price gouging. That is charging unconscionably high prices or unlawfully or unfairly raising prices during an emergency. So we have seen that very recently with insulin prices, as well as with the exceptionally high prices of certain masks and cleaning products during the COVID pandemic, particularly at the start. Finally, states have certain rights as sovereign governments. States can be injured by the actions or the inactions of the federal government, as well as other state governments, and so states have standing to sue both the feds and their sister states. Okay, so I realize that standing, the doctrine of standing, is pretty dry, and it's not necessarily a common sense doctrine. So let's go over an example. Let's say that Congress appropriates $1 million for a scientific grant, and Congress specifies that that grant money is used to study the mating behavior of sea turtles. Let's also say that Congress passes a statute requiring businesses to pay a special tax if they affect sea turtle migration or sea turtle habitats. And those special tax revenues help fund the grant along with funds from the general U.S. Treasury. So we've got 3 plaintiffs file suit. Plaintiff number 1, Kevin Jones. He is a tax-paying American citizen. He believes that this expenditure is wasteful. He is outraged that his tax dollars are being spent for useless studies, and he files suit to block the appropriation. Plaintiff number 2, Transshipping Incorporated. They are a company that engages in ocean shipping. And so Transshipping files suit in that same district court that Kevin Jones did after it was assessed a $20,000 special tax because its oceanic shipping lines interfere with sea turtle migration. And then third, we have the Shipping Union, a membership organization whose members are companies that engage in land, rail, and air shipping. And while Shipping Union members are not currently engaged in ocean shipping, the union believes that the law sets a bad precedent and that similar laws might affect their business in the future, so they file suit as well. So we've got 3 different plaintiffs filing suit to get rid of this appropriation for the grant, as well as the statute that went with it. All right, so we got 3 plaintiffs challenging Congress's actions. Which one of these plaintiffs has standing? Kevin, he's just a taxpayer. He doesn't like how Congress is spending his money, but Congress is not spending the money in a way that violates the First Amendment's Establishment Clause, and so Kevin has no say in the matter. He can join the rest of his fellow Americans in disagreeing with some federal fiscal policy or other. Transshipping is a company that is engaged in oceanic shipping. it has been slapped with a $20,000 tax because of the new law. So because transshipping has suffered a financial injury, that $20,000, due to government action, and because a favorable court ruling would fix the problem, transshipping does have standing, so it can proceed with its suit. So what about shipping union? It is a membership organization. Its members include lots of shipping companies, but neither the shipping union nor its individual members have anything to do with oceanic shipping. That's important because it means they are not competitors of transshipping. So because the shipping union and its members are not competitors, they have not themselves been taxed or otherwise injured. Shipping union has no standing in court. So there you have it. Of the three plaintiffs, transshipping is the only one with standing to sue. All right, that is it for the week. You have nothing due this week. I have opened up the M2 discussion board where you can collaborate as you prepare to write your second memo. But don't worry, that memo is not due until the end of week 12. I am just opening up the collaborative discussion board early. So thank you for listening. I hope you have a great rest of your week, and maybe I will see you on the discussion boards.